Okay, good afternoon, everybody. Thank you for joining us here today. This is kicking off our webinar series, employment law webinar series for Haynsworth Sinkler Board. My name is Joseph Dickey, and I have with me Katie Busbee. We are in the employment practice group, and we have a whirlwind of things to talk about, which we probably don't have all the answers to today. So we're kicking off with our 2025 legislative update and Trump 2.0 today, which we're 3 days into the Trump administration. And what a 3 days it has been. And so we're going to try to kind of cover some of these things today, or at least speak on them, and see what we can at least discuss today, or at least touch on, make you aware of. And we'll be monitoring things as the first 100 days pass, so we can bring you up to speed on it in February or in the interim. Katie, have any other intro?
No, we got a lot to cover, like you said. So,
All right. Just a little bit about the firm. It's the usual. We're a full service law firm, 5 locations across North Carolina, South Carolina, 110 plus attorneys. We are able to handle all your labor and employment needs, as well as other matters that may come and affect you, whether it's corporate litigation or otherwise. If you have questions, please just ask them. We want this to be as interactive as possible, and let us have an interactive discussion. I think that's going to be the way we have to go through this, with the all-encompassing changes that are happening and that are going to affect us as employers going forward. So please, if you have a question, just ask it. We'll stop and try to address it. All right, today we're going to try to have this roadmap. We're going to try to talk about the Supreme Court's attack on agency authority that kind of started last year. So we want to make sure that you understand that what's happening now started last year, and kind of lead you up into the Trump administration 2.0 part due. For those of you who are of my age, you'll understand Hot Shots part due. That's dating myself, don't judge me. So I thought that was funny, probably just me. Then we're going to give you a state legislative update. There may be other bills that were filed locally in South Carolina, but we didn't want to bombard you. So Katie and I took what we thought was most important and kind of want to highlight those for you. And then there are some cases and federal law updates we want to provide. We put ADA, FMLA, FLSA, and Title IX down there, but we also have a brief Title VII update involving job transfers that occurred in a Supreme Court case last year that we kind of want to mention, because it kind of changes what is an adverse action under Title VII. Things we may have been doing may be considered adverse actions now. And as for Title IX, a lot of executive orders are going to impact Title IX. So that's kind of our roadmap today. Katie, you have anything to kind of say about some of these things?
no, I think I'm good for right now.
All right. So let's jump into agency rulemaking. So last year we had a couple of cases that came before the Supreme Court, notably Loper Bright Enterprises versus Raymondo. In this case, this was a companion case with another case called Relentless. I forgot the full name, where the Supreme Court undertook the question of whether or not there was the agencies, that court should still defer to agencies' authority or opinion on certain statutes or certain issues, just to kind of simplify it. And that arose out of a Chevron case back in 1984, which implemented a 2-step process to defer to the agencies on ambiguous statutes. So, for example, you have an EEOC that has guidance on harassment or other employment or EEO related items. The courts would defer to the EEOC's guidance and maybe issuing an order, like an order on summary judgment, which I'm sure some of us have seen before. And the Loper Bright case and the other case that the Supreme Court took up collectively were challenging that kind of standard, or challenging that thought process. And so what the court did is look at, first step, whether Congress's intent was clear in the statute. Did Congress expressly give the agency, whether that be EEOC, SEC, whoever, express intent on opining on the statute or, adjudicating the statute or otherwise? And then if it's the second step, once you determine that, if it's silent, the courts would be required to defer to the agency's interpretation if it was permissible. All right. So in doing that, the court said, we're going to reject, some of that. And now we want to look at, okay, we're going to say that the courts decide, not the agency. So now EEOC can say, all right, this is how we feel about harassment. This is how we feel about discrimination, retaliation. But if someone challenges it, let's say Katie employer challenges the interpretation of that statute or challenges, or there's an issue, her employee challenges her termination and it hits on those guidance or that statute, the court that is adjudicating that claim will be able to make its own decision independent of what the agency says, aka the technical holding. The Administrative Procedures Act requires courts to exercise their independent judgments in deciding whether an agency has acted within its statutory authority. Now, doing this has eroded several years of precedent and kind of strips the administrative agencies of some of their authority. Now, it's not yet to be seen how that's going to impact, but that case happened. And not only did that case happen, we moved to the SEC versus Jarkesi. Katie, you know how to say it? I don't know how to say it.
I'm not sure.
Now, this case on its face looks like it's simply a case about an investor and his investment advisor challenging the SEC coming after him for fraud. But it has rippling ramifications for all agencies. And so the court, again, same term, 6-3 majority, written by Chief Justice Roberts, kind of just looked at the case and said, all right, we want to take up this issue of whether or not the agency can just strip somebody of Seventh Amendment right to a trial by jury and come after a individual under claims that they could bring civilly. So in analyzing the case with Jarkesi, the court looked at, does the enforcement action implicate the Seventh Amendment? And so in doing that, they say, all right, or is this claim going to be the enforcement action? Is this something that the defendant, i.e. the individual that or the entity defendant, whatever it may be, that is being, prosecuted, are they entitled to a jury trial if this was in court? Okay. If it is, second, you look at, does the enforcement action concern a public or private right? So public right would be, something that was, a issue that could not be brought into courts, and something that the agency would have to adjudicate. Private right would be something that the agency, the SEC, could just bring a very common law action in regular court against the defendant. If the agency in its enforcement action can bring that private right in regular court, then it would implicate a private right, and the court determined then that if that's the case, then the defendant, i.e. Jarkesi, is entitled to the jury trial. So, kind of going back, what this means is the SEC cannot bring securities fraud allegations or enforcement action against a defendant internally where there's an SEC prosecutor, an SEC administrative law judge under SEC regs, when it could bring that same securities fraud case in court civilly and get the same penalties. What does that mean? If that can happen with the SEC, then the EEOC similarly. The same analysis could apply. The EEOC cannot bring a discrimination action against an employer within the EEOC's administrative law court with EEOC prosecutors before an EEOC judge. because the defendant, the employer, would deserve a jury trial under the 7th Amendment. So you take these two cases together, Joy Kessie and Loper Bright, and you see a clear or a very direct attack on administrative agency authority and the erosion of the same, putting things back into court and letting the courts kind of shape the law and having more authority in how they want to analyze the law. And this changes things for employers, makes things a little more employer friendly. Your EEOC, let's say you get a 4 cause action, a 4 cause determination on a claim. It already didn't mean too much, but now it really is, at least in our opinion, really doesn't mean anything. And so it just shows where the court is going. And this, truthfully, you can start, and we're going to get into this, back in Trump's first administration, when you had the appointments of the 3 justices. So I think it was Judge Gorsuch, Judge Kavanaugh, and Justice Gorsuch, Justice Kavanaugh, and Justice Barrett. And so these appointments that President Trump made back in his first administration, leading up to now, kind of started initiated the slow crescendo that we're seeing, going into more employer-friendly statutes, more employer-friendly court, more employer-friendly decisions, and venues that we're about to have. Katie, you have anything you want to comment on that?
So I will say it looks like we have a question in the Q&A. What is the standard of review for courts looking at the agency interpretations now? If no deference, is it akin to de novo in the appeal context?
Say that again.
So what's the standard of review now for courts reviewing agency interpretations? And would you say it's similar to de novo review in the appeal context?
To be honest, I guess it's hard to say, because the court in Loper Bright also said any decision that relied on Chevron in the past is not overturned. And it also did not, I'm just trying to find something. It didn't overturn any prior decisions of relying on Chevron, and the EEOC and other agencies can still operate in their capacity. So it's not affected them, I guess, outright yet, but clearly, the framework's there. So for right now, I would opine that, de novo would be the closest thing to it, unless there's some clear express intent that by Congress, such as in ERISA. And you probably wouldn't see any effects of Loper Bright on ERISA interpretation or ERISA cases.
Yeah, I agree with that. And I do think the courts, in reading the case and doing some research leading up to this, courts have been moving away from deferring to agencies for some time. All of you employers out there know that it seems like every time we get a really controversial DOL rule or EEOC, that gets litigated, and a lot of those have been struck down by courts. And so there has been this kind of move away in the last 10 years from courts giving a lot of deference under Chevron anyways, but this case really solidifies that.
All right. And we go to the next slide. I know we've kind of talked about that. Katie just mentioned it. That you've seen the vacating of the Department of white collar exemption rule out of Texas federal courts, also the final tip credit rule, both of which we'll kind of hit on today. And just with President Trump coming in, there's been, I think we all heard the 100 executive orders that were signed on Inauguration Day. And while they haven't outright kind of repealed the child labor violations or Pregnant Workers Fairness Act, these are things that could be on the table as we move forward into the first 100 days. President Trump told us what he was going to do, and he certainly is following through with it. And he's doing it in a big way right now. So these are just things to kind of look at as you watch how the first 100 days play out in the new administration and how the courts have been leaning. You go next slide. Right here, I don't want to beat a dead horse. We've kind of talked about it, but when it comes down to state interpretation, here we have the South Carolina Human Affairs Commission. Now, the states can still, have their own interpretation of things and whether they're going to defer to a state agency or not. But there are some states that have decided outwardly they're going to apply Loper Bright and the new standard. Is yet to be seen what we do. I could see us maybe taking a position to outwardly put that out there that agencies need to apply local bright. But as of now, at least to my knowledge, Katie, to you, nothing has happened like that as of now. So it'll be interesting to watch and how this may, at least to try to influence or affect authority of state agencies that may have their own internal programs, and quite frankly, maybe the internal grievance process. I know with state HR, maybe some of you on here have to at least model the state HR grievance process, which, would be akin to similar to the SEC issue in the Jorkesi case, to see how that may play out. I don't see it affecting it right now, but who knows? Anything's on the table. All right, now we got some of the more detailed discussion I think Katie's going to handle regarding the tip credit rule and some of the other decisions that have happened post local bright that you need to look out for in 2025 as we continue to go through the new administration.
Yeah, so there were a number of agency employment rules that came out kind of the second half of 2024 after Loper Bright, and several of these agency rules were struck down, and some of them are still under review. And so, we talked about the DOL salary thresholds, the FTC rule banning non-competes. We're going to go over a little more of that later. The tip credit rule was also invalidated post Loper Bright. And so, that was a rule put out by the Department of Labor that, basically restaurants get a tip credit under the FLSA. So you can pay your servers $2.15 an hour, and as long as they make minimum wage with their tips, that's fine. And the Department of Labor had put out this rule that tried to narrow that and take away that tip credit for employees who spent 20% more of their time on non-tipped activities or spent 30 minutes or more on side work. So things like rolling silverware or cleaning up at the end of the night. And so the court said basically no, that was an overstep of their authority, and that, the tip credit exists for these types of employees. And so that rule was also invalidated. One rule that I think is still kind of up in the air, what's going to happen after Loper Bright, is the OSHA walk around rule, which also came out last year, that allows employees to have a representative to accompany OSHA personnel carrying out an investigation. And so, we'll kind of see if that rule ends up going the way of these other rules, that it's also going to be invalidated, or if that survives this review.
That's good. And that kind of takes us into what has happened since January or since this week. And President Trump has made some sweeping decisions, and I think there are more to come in reshaping the agencies as well as his cabinet. We've put on the slide a list of the people we at least know have been either nominated, announced, confirmed. And the thing about the nominations, these are people that are, these are partisan nominations as usual. And so you're seeing a shift from Biden era strict enforcement or aggressive enforcement from agencies and rolling out agency rules to probably having seen that roll back pretty aggressively from Department of Labor to the NLRB and the EEOC. I know we've talked in previous webinars about the unionization efforts of private employees and some other union type, NLRA type issues that have been coming up with private employees. And we're going to see, if it's kind of been hinted at, that that's going to be scaled back with the new general counsel, new chairman that's taking over in the National Labor Relations Board. So that's something to watch out for as we go forward. Also, specifically, if you go to the next slide, what the big thing that has happened is President Trump rescinding Executive Order 11246. If you're not familiar with that, I know my wife is, and she practices in that area, is that it requires government contractors with 50 or more employees who have government contract 50,000 or more to maintain affirmative action programs. I.e., the short of it, you need to maintain, guess, EEO policies and treat and give fair opportunities for contractors or employees under your grant or contract that you may have with the federal government. President Trump has rescinded that order that was, I guess, enacted by President Johnson over 60 years ago, or roughly 60 years ago. This has caused shockwaves throughout the employment law world. Shockwaves, outrage, however you want to call it. And it's going to have far-reaching ramifications. The question of whether existing contracts, are they still valid? If there's a procurement out, if there's a negotiation now, how does that impact things with the rescinding of the executive order? It's just a lot of framework, a lot of things that people have to consider. Working with counsel to try to work those issues out, something that we would advise employers to do. In doing the rescinding of 11246, President Trump has also directed the Office of Federal Contracts and Compliance Programs to stand down on enforcement. So, on-site investigations, filing suits or whatever they would do, stand down, telling them to hold off. Also putting I guess what you would call diversity, equity, and inclusion workers on paid leave. Those are also orders, or I guess directives that President Trump has given. In doing so, you can look and see that that's going to apply also to, or at least it seems like it's going to apply to EEOC, National Labor Relations Board, Department of Labor, all the agencies to stand out and not be as aggressive in their enforcement actions as we transition into the new administration. There was also a rescinding of Executive Order 13672, which shielded contract workers from discrimination on the basis of sexual orientation and gender identity. So this came from the order, which I believe President Trump said also in his inauguration address, is that it shall be the policy of the United States to have two genders, men and women. And so, again, just like the DEI, any DEI efforts, DEI programs, and encouragement, employees putting a halt to that. Similarly, this is now any program, activity, or regulation guidance that is concerning sexual orientation, gender identity, putting a halt to that, because under the new administration we're acknowledging male and female. Now, Title VII still exists, but President Trump in his executive order, which if I'm calling it right, I think it's titled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government Executive Order, actually kind of addresses the Title VII in his executive order. If you may recall, on the Bostock case that was in the Supreme Court decided, it said that Title VII would address discrimination based on gender identity and sexual orientation. President Trump, in issuing this order, has directed the Attorney General, or I think it is the Attorney General, to issue guidance to agencies to correct the misapplication of the Supreme Court's decision in the Bostock case regarding sex-based distinctions and agency initiatives. Also of note in this executive order, President Trump, if I'm not mistaken, also has rescinded the EEOC harassment enforcement guidance on harassment that was issued in April of 2024. So this is a far-reaching order that is really trying to eradicate any guidance or enforcement or other laws or protections for those that are looking at gender identity or sexual orientation. And this is where the Title IX is being impacted There's a laundry list of Title IX, the guidance that has been issued over the course of the past 4 years that this executive order also has expressly identified as being rescinded. I think we're, Katie, do we have a question? Can't hear you.
Sorry about that. We have a question that says, if we are a private employer and currently have a DEI program, should we consider any changes?
So that's a good question. I think it's always good for you to look at your DEI program. There have been cases, one that came before all of this started happening back, I think in 2019, 2020, I think it was in North Carolina. It was, I think Duval versus Novant Health, where, you know, basics is a reverse discrimination claim, but it challenges Novant Health's DEI program. I wouldn't recommend that you just forego doing your DEI program, but I would evaluate it and, you know, and look at it and see, all right, your goal is DEI, diversity, equity, and inclusion. Let's make sure that we're doing that. Let's make sure that we don't have scenarios in there that might subject us or expose us to any challenges to where we're not taking in, not fairly going into the equity and inclusion or the diversity of it, but we're just making decisions solely based on classifications. Because if you look at the Duval case in North Carolina, I think it was back in 2020, 19 or 20, the Novant Health DEI program came under scrutiny because it was enacted in 3 phases. And in those 3 phases, people were getting terminated, executives got terminated, not because they were bad employees, not because they weren't doing their job, but simply Novant Health. And this is the unfortunate part of the DEI program. Some aggressive DEI programs, Novant Health just replaced them or would split a job in 2 and replace somebody and say, all right, Katie needs to go, and because we need an Asian person to be in her position, or we can add 2 Asian person and a Black person in that position and split the position in 2, and then we'll meet a quota and we'll just fire Katie. That's not DEI. That's shifting pieces on the board. That's and just trying to meet quotas. And that's not what DEI is for, or affirmative action. And so that's why Novant Health's DEI program in that situation, they lost that case. It was appealed, they lost again. So it's always good to review your DEI program. I wouldn't say eradicate it, but similar as you would look at any other policy, your handbook annually, I'll look at your programs as well.
Yeah, it looks like we have a second question too. If we are a local government here in South Carolina and have DEI committee and initiatives and we receive federal grants, do you have guidance?
That is a good question, and that's a hard question to answer.
Yeah, that one's harder.
It's very hard to answer. I think if you have DEI committee and initiative, like I kind of advised on the first question, it's always good to review it. I would like to see, you know, if those federal grant, is it coming into directly impacting the program that you have the DEI committee with or anything. I think it's just a lot of variables right now, but I would want to evaluate it and see what we need to do. You are state government, you're not federal, so technically you aren't bound by this executive order. You can still do what you need to do, and just kind of look and see where these federal grant monies are going, and is your DEI program, you know, subject to some challenges, and is it directly correlated with the grant money. But for now, I would probably just evaluate it and then keep moving forward unless instructed otherwise by the state government. I think we got something in the chat. I'll read it. Are there gaps in our federal and state labor laws that DEI initiatives should address? Or should we rely solely on existing state and federal laws? That's another good question. I think there are some things that DEI does address and DEI initiatives address. You know, state and federal laws do have protections, you know, for in hiring, firing, or in just everyday employment life. However, the DEI initiatives, if done right, do assist in trying to create a equitable and more diverse and inclusive workplace. Now, that still considers merit. That still considers achievement, evaluations, and all those things. It's not, it's not just, all right, we're putting Katie in this position because she's a woman. And so if done right, implemented right, it will fill in certain gaps and just kind of make an organization better or assist the organization to being more diverse. But needs to be evaluation and be careful and mindful of how it's implemented.
Yeah, and it looks like we have one more. By keep moving forward, do you mean continue our DEI initiatives as we have been?
Subject to your evaluation of the same. Yes, I would do that, but I strongly recommend that you evaluate it and see kind of what your initiatives have been achieving, and how are you implementing it? How does that look going forward, to make sure you aren't subject to any challenges? And that's something, Katie, or I can assist you with, because you don't want to have your, and let's say, taking it back to something my mother would say, you don't want to have your good be evil spoken of, so to speak. And so you want to make sure you're doing it in the right way.
Yeah, and I would expect too, Joseph, that we are potentially going to get some regulations or guidance.
Oh, yeah, it's coming. It's
Yeah.
coming. Yeah,
And so we'll know better how to advise at that point. But yeah, for now, review of your systems and policies.
right. We're 3 days in, so I'm sure something's happening right now as we're talking. All right. Yeah, so I think we're looking at the slide. Clearly, yeah, there's been a rollback of DEI initiatives, rescission of memos, updated. I can't say that all the things are being rolled back. all the things from DEI, enforcement of the employment related agencies, immigration, non-compete rules from the FTC. That was a big deal last year. Probably not going to get implemented. Immigration reform, we had the executive order talking about birthright citizenship is no longer a thing. There are broad sweeping things that are happening, and I'm sure, just as Katie said, it's going to continue. There's going to be continued regulations or guidance that's going to be issued. So 3 days in, we clearly don't have all the answers as of yet, but evaluating systems, processes, certain things that are going on in your agency or in your organization right now is probably prudent. All right, and so now we're looking at the salary thresholds. This was the big thing last year where there was the drastic increase in the non-exempt and exempt pay scales. And Katie's going to get more into it, but you could expect this probably not to continue to be challenged and probably not succeed in the way that it was thought to succeed. But Katie, I'll let you kind of dive into that.
Yeah, so I know all of you know out there that we got a rule last year raising the salary threshold for exempt workers. And that was supposed to go into effect in 2 phases. Next slide. And so that first increase went into effect July 1, and I know we helped many of you prepare for that and send out notices to your workforce about, moving from exempt to non-exempt. And then the second raise was supposed to go into effect January 1, but we, of course, got a decision from the Eastern District of Texas vacating that rule. And they basically said that the salary increases were such a large jump that the test had basically become all about salary and not about the duties test. And they also talked about how historically, typically we get a salary increase about every 9 years, and that it's typically set at the 10th percentile of salaried employees. And so this jump that we were getting ready for on January 1, that was supposed to go into effect, was at the 35th percentile. And so it was much higher. And so now, as a result of that that court decision, we are back to the 2019 rule that was in effect before July 1. So before that first increase. So we're back to the $684 a week. And the government has appealed that decision as of now. And so the question really from what we've been getting from a lot of you is what's going to happen under the Trump administration. And I put deja vu on this slide because we actually already went through this under Trump 1.0. And so we have a chart here. So in 2004, up until 2019, really, we had $450 a week as the salary level. And a lot of you might remember that in 2015, late 2015, we got a rule as the Obama administration was moving out that raised the salary thresholds quite significantly. In fact, I think that raise was also around the 35th percentile. And again, that was vacated by a court. But, you know, when Trump came in his first administration, you know, he appointed a new Secretary of Labor, which he's already done for this round as well. And they did raise the salary thresholds in 2019. And so it wasn't as large of a jump that was proposed as in 2015, 2016, but they did raise it. And that's the standard we currently have. And so, you know, it's very likely that they could end up still increasing the threshold at some time during his administration. I would expect it to be not as large of a jump as we saw with the other proposed rule. But, you know, the 2019 level, inflation has been on a tear since then. We all know that. It's probably reasonable that those salaries should be raised some. And so I wouldn't be surprised if we get that at some point.
And Katie, we got a question here. Why does the finding of the Eastern District of Texas bind the whole country rather than just in Texas?
You know, that's a really good question. It is something that every time they come out with these decisions, I have found very interesting that a district court can bind the whole country. I don't know, Joseph, you might actually know the nitty-gritty of that that better than I do.
Well, the short of that would be federal law, federal court. The federal court would stay the implementation of the federal law. So if that federal law is binding in the Eastern District of Texas, just as that federal law would be binding in the District of South Carolina or in the Eastern District of New York. And so if the federal court judge issues the injunction, then the federal law is paused for implementation throughout until there's been a resolution or adjudication otherwise.
Yeah, and they have appealed. So, you know, we'll see. The Trump administration isn't expected to necessarily vigorously pursue that appeal. Okay, and so we also had a big rule come out last year, the FTC rule banning non-competes. And that rule came out in April. It was set to go into effect, I think, the first week of September. And again, I know all of you were working to update your agreements and prepare for that. And that was also vacated by a Texas district court on August 20th. And so that has been appealed, but it's not expected that the Trump administration will pursue that appeal. It's very unlikely that they will. And I think Trump has already kind of alluded that he really feels like, you know, non-compete laws are left to Congress or the states. And I think it's probably unlikely that Congress would pass anything with it. And so a lot of states are taking action. And we've even got, when we get to the South Carolina legislation portion, we've even got a bill pending here. And so I do expect to see that more states have this type of legislation. Okay, so I'm going to hit on a few bills. So we just started a new session with the South Carolina legislature. And we looked through the bills that have been filed so far. And, you know, South Carolina is a very employer-friendly state. And so we don't get a ton at the state level that, you know, it's kind of rare for us to get a bill, honestly, that is really like a landmark bill in the employment sphere. But we do have a few bills that we just wanted to put on your radar. And, there's always bills every year that do things like, there were a few bills raising minimum wage to like $20 an hour or things like that. There's always bills like that filed. And so we're not necessarily going to cover those just because those are kind of just filed every year, and a lot of times they usually don't go anywhere. But the ones we have on today, I think, are trends across the country that are happening in states, and it's also been proposed here in South Carolina. So ban the box legislation. We do usually have a ban the box bill, and that is becoming more and more prevalent in states and in cities and towns. We're getting local ordinances. And so that essentially means that job applications cannot include questions related to criminal convictions unless the conviction directly relates to that position. So, and really, actually, you can't have it on the application, but you can ask about it after a conditional offer of employment has been made or after the interview process. You can then start to inquire into convictions, but you can't just put it on the application, send it to the employee. And this bill in particular has some factors you have to weigh, and they're very similar to the factors under the EEOC guidance when you're weighing arrests and convictions. When you get something back on a background check or you get informed about an arrest or a conviction. And so, again, I think a lot of states have probably already passed this. I know the city of Columbia has an ordinance, ban the box. And so, this is also a growing trend. So this is something to watch. There is a bill a couple years ago, South Carolina enacted a bill that gave paid leave to state employees and employees of political subdivisions. And so there's currently a bill to expand parental leave. So currently they get six weeks. This bill would expand it to 12, and then also expand leave for partners that are not directly involved in the caregiving of a child from 2 to 4 weeks. And so I think that bill went into effect 2023, I think. So this would expand that leave that was created. And then we also have a bill that's been introduced that would essentially ban non-competes and non-solicitations for physicians. And so this is kind of what I was saying. I think a lot of states are going to pick up these bans for non-competes. And so we do have one filed here in South Carolina that would relate to physicians. There is a carve out for situations where there's a sale of a practice. If that non-compete would be for 5 years or less, that would be fine. But again, this is something to watch if you're in the healthcare industry or you employ physicians. And I think physicians is very broad in the bill, so it can encompass a lot of different types of doctors and medical staff. So that's just one to watch as we go forward.
All right, and I would like to say just before we move on, in regards to the paid leave, I know there are some private employers, some of y'all that might already do this, the paid leave, and that's fine. But just be mindful of how you implement it. If you're implementing it where it's fair and you can't be challenged for disparate treatment, or you're implementing it where somebody might say they got FMLA leave. So the communication needs to be clear, because if someone thinks they're getting full out FMLA leave, yet they're not eligible, but they are eligible for the paid leave, you can have things get confusing and find yourself in a bit of a pickle. So communication needs to be very clear, needs to be very expressed if you are in fact doing that as a private employer. Now I think we got a question, Katie. I'll read it out. I just saw it come through. Can you have the question regarding convictions on your ad on a job board?
Okay, so I mean, it depends where you are, where you have these employees and where you are doing business. So I think in South Carolina, just statewide, of course, we don't have a ban the box rule, but you have to be careful that some cities do. And so I think technically, as long as you're in a state or a city that has not banned that, you can. But I think most of our employers now have honestly started to move away from that, just because there is this trend of adopting ordinances or laws or things like that where they are starting to ban it. And so I think a lot of employers don't want to have to keep up with that. And so I think, you know, the answer is it depends where you are because it varies. Technically you can as long as you're in an area that hasn't banned it, but I think the prevailing thought behind is a lot of employers are moving away from it. That's been my experience, Joseph. I don't know if you have anything different.
No, likewise, my experience as well. And quite frankly, we would probably tell you, you know, probably just leave it and once you get to your internal documents or things of that nature. Because I still think you kind of expose yourself. People just from doing plaintiff's work on the in the past, people will apply for a job and then immediately call the lawyer just to run it by him or her. And so people are starting to move away from, like Katie said, if you call and ask us to kind of what to do, we probably would say, well, probably not do it. We got another question. Skilled nursing facilities cannot hire individuals with felonies due to dealing with a vulnerable population. Will the ban debates include healthcare industries?
So there is a provision in the bill, and again, I just looked at this over the past couple of days, but it basically has a carve out, and I'm pulling it up in front of me. That I think says is if you are by statute either required to run background checks or to not hire people that have felonies or certain types of felonies, if you're required by statute, then basically this doesn't apply to you, is I think what it says. And I can look at it in detail and get back. Oh, it looks like it's an anonymous attendee, but I think it did have a carve out for anyone that by statute cannot hire certain people.
And if that's something that you want to follow up with us on, please feel free to email me or Katie offline. We'll be happy to address the same with you in more detail. All right. We don't have any questions on that. I know we're running low on time, and we do want to leave some time for some more questions. So we'll try to jump into the case law update. This first case, I'll kind of try to be brief. The first case hits on FMLA. In short, the plaintiff employee was receiving intermittent FMLA leave for hypoglycemia related to his type 2 diabetes. Later, some months later, he got some more FMLA leave for the same condition. And then in April, and so this has been, I don't know, it's been a good number of months later, he took 2 days off for neuropathy related to diabetes. Now, when you look at that, he's had hypoglycemia for the first grant FMLA leave, and then he took off for the neuropathy that was related to his diabetes. His employer, however, saw that the certification was only for hypoglycemia, not neuropathy. Now, I mean, I look at that and say, all right, diabetes has neuropathy, you can have neuropathy as part of it, hypoglycemia. That's how I look at it. This employer did not. They said, well, these are two different things. So the employer thought that the plaintiff was misusing his FMLA leave, said the neuropathy and the hypoglycemia were different. Wasn't so sure about all that, and so he was let go, if I'm not mistaken. And so the employee brought suit for FMLA interference and retaliation. District court dismissed his case, and then he appealed, and the Fourth Circuit affirmed. What was the kicker here is that whether the employee was misusing the FMLA or not, the court said it didn't matter. The court said that the employer had a good faith belief that he was misusing it, and so the action they took based on that good faith belief was valid, and they upheld it. And so that we found that to be interesting because that kind of gives some leeway or gives the employer more discretion. If you think somebody is misusing FMLA, even if the paperwork looks on the up and up, if there's something else going on and you're looking at it and you think there is a reason for some differences or something looks a little suspect, You have the discretion to kind of take action as you see fit. Now, that doesn't prevent you from getting sued. No, I know sometimes we want to say, all right, we did our due diligence, we talked with counsel, and now we shouldn't get sued. Well, that doesn't prevent the suit necessarily. It helps try to prevent it, but it also helps mitigate if the suit comes. And that's what you want to happen. And so with this case, we thought it was important to bring to your attention that it gives employers more discretion into trying to into making decisions, personnel decisions, even with FMLA is involved. The next one is Kelly versus Town Abington. This one involves a town attorney. I think we're on slide, what would that be, 27? Or for the Kelly versus Town of Abington, or 26 rather. This involved the town attorney that was later became a town manager. This is an ADA case, looking at accommodations. In short, the plaintiff, the employee, said the work environment was hostile, counsel and people made his anxiety, depression worse, caused his pressure to get up. And so he had a attorney, I think his attorney, or he sent a memo to the town saying accommodation request, and talk that where they were talking about, these are things that could help me, have a well-running office. Basically saying, y'all leave me alone and get things smooth, and I won't have all these problems. Didn't really mention his conditions, but this is what y'all need to do. That's basically what it was. So nothing changed. If you read the case, it seems like they just didn't like this person. He eventually resigned, and then he sued for failure to accommodate and retaliation. The Fourth Circuit, it got dismissed and was appealed, and the Fourth Circuit basically said that the town had notice of his disability. However, there was no accommodation request. That memo that he relied upon, where he basically, had a festivus and aired his grievances of what y'all need to do to help me be better for you, was just an airing of grievances that did not make a specific accommodation request. And without that, there is nothing that the employer can do, and it's putting everybody on slippery slope, i.e., if accommodation request has to be made for every little personality difference or minor aggression or grievance, then that's untenable. Specifically, the court said personality conflicts, technical difficulties, and challenging assignments can all exacerbate anxiety system, but employees frequently request workplace changes to address these situations for reasons other than their disabilities, such as workplace comfort or efficiency. Using the employee's argument, any employee with anxiety would be entitled to the full protection of the ADA at any time his employer could anticipate that such changes might improve his symptoms. So I feel bad today. The paint on the wall does not suit my mood. I'm going to complain, and Katie's going to change that paint. Tomorrow, I didn't like the coffee. It makes me a hostile work environment. My pressure went up. That's basically what the court is saying. And so, that really just goes back to our advice that we usually give. There must be an interactive process. Have clear communication. I can't say it enough. Clear communication. So you understand what the requests are people are making, whether it's accommodation or FMLA. Lastly, it's not in the slides, but this happened last year as well. I'm gonna be quick. On the Title VII, Supreme Court addressed the Muldrow versus City of St. Louis case. This case basically says that a job transfer of an employee can be in violation of Title VII, even if the employee has the same rank, same pay. Because certain perks or benefits of the job or standing, that can be considered, if that changes or is lowered, so to speak, that can be considered adverse action. And strangely, the Supreme Court was unanimous in this decision. So basically, this officer was a plainclothes officer specializing in an intelligence division and had FBI benefits. She got a new commanding officer and who wanted to put her on another patrol, which eventually happened. And she lost her FBI benefits, which included a unmarked car. She also couldn't go to the FBI and work on FBI projects, and wasn't part of the intelligence division. She still had same rank, same compensation. She sued based on sex discrimination, and the employer defended that there was no actual material adverse action. The Supreme Court said no. There was an adverse action because she lost those benefits, the FBI benefits, the unmarked car, despite the same pay and same rank. So they remanded the case. So we wanted to put that out there because sometimes I know we do reassignments or job transfers when we're trying to address some issues in the workplace. Just know if that transfer may cause somebody's benefits or something, or might materially affect their, I guess, standing, or their, it's not standing, but their, I guess, benefits they had in their actual position, that could be looked at as an adverse action. So we just need to make sure we're being careful and cognizant of all the ramifications that could affect the employee if we're looking at a transfer. And so with that, we have 4 minutes left. We know you could be anywhere in the world, eating lunch and having a peaceful lunch break, but decided to be here with us. We hope we weren't too boring for you. But if there are any other questions, we'll be happy to answer them. And if you think of others later, we will answer those too offline. Just let us know. Any? I think there is a last one. We are working on a demotion of an employee in the police office. Chief does not want to cut his pay. Happy to talk with you offline on that. Please send me an email. We would need some more information on that, but happy to talk with you about that one offline. It could occur. You could make that action, but I would need more information.
Yeah, and we had a couple questions about ADA interactive process about that last case. And so, the employee has to put the employer on notice that they have a disability, and they have to request an accommodation. And the court basically said in that case, the accommodation request has to have a nexus, has to ameliorate the symptoms of that employee. And like Joseph said, it can't just be like, I need the color of the wall changed or whatever. But when they make that request, once you're on notice, they've made the request, you do have to engage in the interactive process with them. You have to kick off that conversation. And if it is accommodation you can make that does not cause an undue hardship, you do have to accommodate. Now, you don't have to give them the certain request they are necessarily requesting. That's a part of the interactive process and figuring out what are they needing and what can we provide as an employer. You can provide an alternate accommodation that fixes the issue. But yes, if it doesn't cause an undue hardship, you have to find that accommodation.
All right. If there are any other questions, or if they are, please feel free to contact myself, contact Katie, or anybody in our employment group. We would be happy to assist you. We thank y'all all for attending these webinars. And we hope to see you in February, where we'll probably have some more changes that have occurred, given the pace of things. But again, thank you again, and we'll see you next time. Bye.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.